Untitled Ip presents Series 6 of the Hip Talks, Family Matters, a compelling podcast collection delving into the complexities of family law in Hong Kong. This season, our expert solicitors engage with preeminent professionals, psychologists, financial advisors, and mediators to explore the real stories behind divorces, custody battles, and financial disputes. Untitled Ip brings you this series as part of our commitment to modern, client-focused legal services. Whether you're navigating family law issues or simply interested about the system, Family Matters delivers sharp analysis without the jargon.
Hello everyone, welcome to Hip Talk. I'm Alfred Ip, a partner at Untitled Ip. Today, we have a very special guest. Richard, can I ask you to introduce yourself?
Indeed. My name is Richard Wilson, and I'm a barrister at Serle Court Chambers in London, where I specialise in trust law. And I work in England and across a range of jurisdictions, particularly offshore jurisdictions like those in the Caribbean. And from time to time, I have the pleasure of working on cases with you relating to Hong Kong.
This is the reason why I brought you all the way here from London.
Well, it's always a delight to be here in Hong Kong.
Thank you very much. And there's one part in your title that we need you to explain a little bit about. What is a KC?
It's King's Counsel, which is a particular sort of barrister. You get to a stage in your career where you can make an application, and if you're fortunate like I was, you get accepted and you get the rank of King's Counsel.
What does one have to do to be fortunate enough?
Well, you have to be nice to people for quite a while because you have to fill in a lengthy application form and have referees. You have references from judges, from your opponents, from your clients. It's quite a tortuous process. And I have to say, when you get the letter saying that you've been appointed, the first feeling is one of relief that you're not going to have to go through the process again.
But then it is a huge honor, isn't it?
Yeah, it's great. It's great, and certainly the ceremony when you actually become a King's Counsel is in Westminster Hall in Parliament, and you have to wear your ceremonial outfit, which involves a really long wig and knee breeches and all sorts of things. It's great fun. It's British tradition at its best.
But then actually, I was talking to another friend of mine who is also a senior counsel in Hong Kong. And one of the things that we were talking about is in order to be a senior counsel in Hong Kong, which is the equivalent of King's Counsel in London, one thing that you have to be is to be honest and truthful, especially in your submission to the court. There cannot be any circumstances which you may come across as misleading the judges. Is it the case in London as well?
Absolutely. It's the golden rule. You mustn't mislead the court.
But this is exactly the reason why I hate to admit, but it's true, that a lot of time barrister or counsel does have a lot of gravity in their submission compared with solicitor.
Oh, I don't know about that, but I'll take your word for that, Alfred.
All right, today, actually, we're talking about divorce and trust. But actually, did we come up with a title for this podcast?
I don't think we did.
Then it's something that probably we should be thinking about at the end of it. Let's see how it goes, okay?
We'll see, yeah.
All right, so let me ask you the first question. You stand at a crossroad where family fortunes meet marital breakdowns. When offshore wealth and complex trust collide with high-stakes divorce proceedings, it's a very long way to say that people using trust to safeguard their assets, not hide their assets, safeguard their assets against spousal claim. Can you share with us some of your experience? What is the real battleground in these kind of proceedings?
Well, it's a very, very interesting question to start with, Alfred. One of the main issues, I always think, in these sorts of disputes where you've got the context of marital breakdown and you're then looking to deal with the assets and often held in trust is that the dispute is much more complicated because of that emotional battle that's going on as well. If you're doing disputes about commercial contracts or anything like that, it comes down at the end of the day to a fairly straightforward economic or financial question.
Yes, it's all about money.
Exactly. But actually, in this sort of litigation, it's always very highly charged emotionally because, understandably, feelings are running high, and that can provide an extra level of complexity because you're trying to deal with people not only for their legal problems, but some of the emotional, psychological problems. I mean, in a way, we're part lawyer, part therapist in these sorts of disputes, and that provides its own challenges, particularly when you're trying to do what you often try to do is find a consensual resolution to the dispute rather than having to go all the way to court and argue it out.
But isn't it more interesting in a divorce with trustee involved? That is, you have two very emotionally charged parties, and yet there's this party in the middle whose job is actually to de-escalate the party's emotion and to do things properly because they have the wealth in their hands.
Absolutely. But that actually makes for its own complexities and difficulties for the trustee, because you can guarantee in this situation you're probably going to annoy or alienate at least one party, and if not both. It's a very important role, as you say. The trustee is often the person holding the assets, and they have an important role to play, particularly in unlocking the whole dispute from that perspective. But the way in which they view their position can often be very different from the way that the parties to the marriage view their position. You might have one party viewing the trustee's job to sort of serve their interests, and the other party viewing the trustee as being, hostile because they're perceived as being there to do the bidding of one party or the other. When the reality is that the trustee has a very important independent role under the trust, looking after the assets and serving the interests of their beneficiaries.
When you have to do the right thing, you cannot please everyone.
Absolutely. It's the old saying as well that no good deed goes unpunished.
You see, doing the right thing override any other motive or any other reason to act one way or another. This is the reason why trustee should be someone who is professional, who has the experience dealing with these kind of issues, and who knows how to do things properly.
Absolutely, and that's particularly important in this context, because the common situation where a trustee gets embroiled in these sorts of disputes is one where assets have been put into a trust structure at some point before the marriage, possibly by one of the parties to the marriage or by another family member, often as part of succession planning. And when the divorce happens, there is a battle over whether those assets can be used for a divorce. And the court, often in an onshore jurisdiction like Hong Kong or in England, will then have to look at what it can do in relation to the trust. And the way in which the trustee acts and has acted in dealing with those assets can be really critically important in deciding what a judge will do and whether the judge will treat those assets as being something that they are able to distribute on the divorce, or whether they have to say, well, actually, these assets just don't belong to the parties. So, and as I say, and one of the factors, as I'm sure we'll explore in this discussion, is whether the trustee's done the right thing, and we probably talk about what that involves.
Yeah, this is actually something that can go on for hours. But let me ask you this question first. For the Hong Kong audience, especially men keen to protect family legacies, what would you say is the golden rule for trust creation that can withstand the fierce divorce claim? And conversely, what are the silent killers, those seemingly small mistakes that can utterly torpedo a trust protective power?
It's in two parts. Firstly, plan early. If you are getting to a point where you're looking to plan and put in place structures to protect your assets against an impending divorce, you are undoubtedly too late. And the other part of the golden rule is make sure that your structure is as robust as possible by, you've already touched on this, having professional trustees who do their jobs properly and have a clear role that they stick to. Because coming to the second part of your question, the silent killer is really this, that where you have a structure that looks like it's independently run and it takes the assets out of the hands of one of the parties, the real killer is where that person actually exercises control under that structure, either legitimately through powers that they've reserved, which mean that they can really control what happens to the assets, or behind what the courts have called a cloak against transparency, where in fact they're controlling them, despite them being in the hands of a trustee who has, it would seem, all of the powers.
I always say when I'm advising clients to set up a trust is, what are you setting up the trust for? If the answer is one way or another, it is our role to actually help them structure the trust in a way that it can withstand the scrutiny of later on when there's a dispute. And this is exactly the reason why a lot of time it's a bit too late when you set up the trust in order to avoid the spousal claim, because there is the presumption, and a lot of the time it's too late because you don't know how to do it properly.
Absolutely. I mean, I think we're both on the same page with this, that if you are looking to put your assets beyond the reach of potential claims, in this context we're talking about divorces, but particularly divorces in this discussion, but also creditors, then it really can be problematic, because the courts have means at their disposal of clawing back assets that have been settled in that situation. That's why I say planning early is much better, because there are perfectly legitimate reasons for doing this. I mean, actually, one of the best uses for trusts is as a mechanism for succession planning, because a trust can live for a long period of time. You put in place a robust structure which has a professional trustee who manages the assets that are in the trust, and that goes on for years, and that means that the death of one generation or two doesn't really affect the way in which the family assets are dealt with, and that sort of planning is really robust. And what is important, it seems to me, is that you have to anticipate that it might come under scrutiny or challenge further down the line, because whilst planning might be done in a very happy environment where the family is all harmonious, and one thinks, well, there's not going to be a divorce here. You've got to hope for the best, but plan for the worst. And what that means is making sure that not only do you put your structure in place properly, you manage it properly, so that all of those the points that I was mentioning before about the control being exercised by people it shouldn't be exercised are dealt with. And a useful exercise that I'm sure we've both been involved in is what's called stress testing, where when you set up a structure, you say, well, look, this is what we want to put in place. And then you look at the potential challenges that might come down the road in the future, and look at and consider how you would react to those, and whether the structure actually needs changing in order to anticipate and deal with those.
I wish that more people would be receptive to the idea of having the structure stress tested. Because, to be very honest with you, Richard, in Hong Kong, a lot of the structure was set up without even lawyers involved. A lot of the time, it's just trustee putting together a letter of instructions or intent or letter of wishes in front of the client, and the client just sign it away. The problem is that later on, if circumstances change and there are something that can be done about it, it might be too late for them to restructure the trust or to do anything to make it robust against this kind of claim.
Absolutely. I think that's a very, very good point. I mean, I think part of the problem where these structures are set up without the benefit of legal advice is that these potential challenges further down the road aren't anticipated fully and properly. And what tends to happen, and I can completely understand why it happens, but that too much control is given to the person setting up the trust, the settlor. It's quite understandable that if you are, particularly where you've built a business yourself, you start that from scratch, it's worth a vast amount of money, and then the advice that you get, very good advice for succession planning, is you need to now give it away to a trustee who gets to make all sorts of decisions over the business. They can sell the shares. They decide which of the next generation are going to run it. That's quite a hard sell, because that element of control over the business that's been built by the client is quite extensive. And what's happened is that structures have built in more and more control for the client, the settlor. And what that means is great. I mean, it suits the needs of the client to have that control, but it does make the structure more vulnerable in a divorce context further down the line, because what the courts can say is, well, look, you can control these assets, and therefore if I, the judge, want to distribute them between the parties to the marriage, I can do that by ordering you to use this power or that power. And so it's very much a balancing act between the control that somebody would necessarily or understandably want as part of the structure and the protection that it will provide against claims further down the line.
I completely agree with you that it's almost impossible to advise patriarch or the creator of the family wealth to all in a sudden let go of all of the power that they have with the assets, basically give it away. In the past, there might be a very legitimate reason, for example, inheritance tax as their duty. If they don't let go for more than 7 years, they cannot enjoy the benefit of tax saving. And it doesn't make the whole process easy for the patriarch. We're still talking about relinquishing the wealth that they very, very hardly worked for over the life to accumulate it. It's extremely difficult. It's almost inhumane. But then at the same time, when we are talking about setting up the trust with all the power reserved to the patriarch or the settler, even telling them that, just because it's a trust doesn't mean that it's no longer yours, the trust is yours, so the trust assets is yours. Actually, it's giving the client or the settler a wrong impression or wrong expectation that the trust is only a paper exercise.
I think you've hit the nail on the head there, Alfred. I mean, the reality is you can't have it all. You can't have control or complete control over the assets and also the protection that you are looking to have, because that's necessarily it comes from giving it away. Now, it's fair to say that it's become fashionable in recent times, in the last 20 years or so, to have trusts where you build in, quite legitimately and quite upfront, a significant degree of control for the wealth creator who's setting up the trust. And, a lot of the offshore jurisdictions make it very clear that doing that doesn't undermine the validity of the trust, all these things. And that's absolutely fine on one level. The problem is when you come before a court, and we've seen it in Hong Kong and in England, where the court's dealing with things like divorce and says, well, look, actually, that's fine. This trust may be valid. It may be legitimate for you to have all these powers. But what it means is that I, as the judge, can make you use those powers to bring these assets into account. And, I do fear that there has been a tendency in certain quarters to make clients think that they can have everything, that they can have absolute dominion over the assets, they can control the levers of power over their assets, whilst having effectively given them away so that they can't be available to divorcing spouse or creditors or tax authorities. And I think that really what we've seen over the last decade or so particularly is an attitude amongst judges that actually, you can't have it both ways. You can't have everything, which brings us back to that question of stress testing, Alfred. I really do think that it's a worthwhile investment for clients to, particularly those who've set up structures 20, 10 years ago, to say, well, actually, let's look at it now in light of where things are, and particularly where you've got the family has developed, you've got another generation, they're getting married, what potential problems might be coming down the line, and saying, well, look, is this structure as robust as possible? And is there anything we can do to make it more robust?
And this is exactly why we always emphasize the importance of trustee having regular review with the client, knowing what the client's circumstances are, whether there are any changes, and whether there needs to be anything to be done with regard to the trust structure in order to make it more updated and perform its function of protecting the family wealth.
Absolutely.
Yeah, and the importance of relinquishing control. Would you say that is the strategic consideration that everyone would bear in mind when they're advising clients to set up the trust? Relinquishing control, it sounds really difficult.
It absolutely does, because I think it's something that instinctively, as I mentioned before, if you've built up this asset base as the wealth creator, relinquishing control of that to a third party is going to be really difficult. But it is that giving up ownership and control that provides many of the benefits. We've mentioned tax, we've mentioned asset protection, we've mentioned succession planning. Those are the benefits that you get from relinquishing that control and ownership. And I think it's very, very important right at the beginning when planning to focus very much on what works for any particular client. I think there is a tendency or a risk of thinking that one size can fit all, and that you can give them all the power in the world over these assets. It's all fine. But actually, I think that the way the legal world has developed, it's becoming more and more difficult to do that, because judges are much more skeptical about structures, certainly particularly in the divorce context. They're looking at ways to do justice as they see it. And one of the things that really is problematic from their perspective is one of the parties to marriage saying, well, look, I've got access to and control over all of these assets, but actually you can't touch them because they're not really mine. That really does lay down a challenge to a judge, and one that we've seen in the courts that they are very much trying to rise to and find ways of bringing those assets into account, because it's the right thing to do in their view.
It sounds like you either do it or you don't. Don't do it halfway. To set up the trust and retain all the power, thinking they can get around, and only giving the judge any reason to see through it.
Yeah, I mean, I think the clue's in the name, trust. Actually, what you want from a structure is to put it in the hands of somebody that you trust, and who will do their job properly. And, very often, if not always, that should involve a professional who's used to doing trust administration properly and making sure that they discharge their duties. Because the beauty of a trust structure is that, the trustee has to act for the benefit of the beneficiaries. They have to stay within the terms of the trust and exercise their powers properly with proper consideration for a proper purpose. And so there are those inherent protections that are there. And if you get somebody that you can rely on to do their job properly, that is the ideal structure. And if you can do that, the need for the control that people want to hold on to becomes much less.
It's easier said than done, I have to say.
I think that's a fair comment. It is. But as I say, we come back to this central point, which is that you can't have it all. You can't give away with one hand and keep it with the other.
Let's say that a client finds it really, really difficult to accept the fact that I need to relinquish all the control that I have over my assets. I cannot trust anyone, which is the case. Actually, most of my clients who try to set up the trust have difficulty trusting the trustee. I understand that it is their problem, but then no matter how much that we want to convince them the trustee are reliable, they will have a problem understanding them. Can postnup or prenup take away this problem of setting up the trust, that is, using a prenup or postnup to replace the trust, or it has to be done with the trust in order to make it impenetrable?
They are helpful. They are something that the court will have regard to when making its decision, and that they will seek to give effect to them. But they're not binding. They don't take away the court's ability to deal with the assets in an appropriate case if they consider them. I mean, it's generally all part of a package of measures if you're planning. Yes, I mean, prenup and postnup agreements are undoubtedly going to be helpful in these situations, but they're not a substitute, I don't think, for robust planning and careful planning, which takes into account the things that we've just been talking about and the need not to give an obvious way into the assets. I mean, there are other things that can be done. It's quite common to have a private trust company, a PTC, as the trustee, which, as a company, it's got a separate legal identity from the wealth creator, but they can sit on the board and exercise some control in that way. And I know that's a popular a solution. It's not without its own problems from time to time, but that can be a way of doing it. So again, with careful planning at the outset, it's much easier to sort of navigate these various problems. But you've got to sit down and think about them carefully. But all too often, so dare I say it, not when it's a structure set up by lawyers or experienced professional trustees, but when it's set up by others, perhaps some other intermediaries. There's a tendency not to put in the effort at the beginning of doing the what if planning, as I always call it, of saying, well, what if somebody gets divorced, or what if there's a big tax bill? All of these sorts of things, all the things that people don't like to think about, the problems further down the line, and factoring them into the planning.
Because they don't want to think about those things.
Absolutely. But I mean, that's really, in this context, the most important thing. And perhaps our job as lawyers is very often making people confront the unpleasant things that they don't want to confront. That's why we're always so popular, Alfred.
I always say that if you just want to hear things you want to hear from me, then I'm probably not doing my job properly. I'm not here to say things to please you. I'm here to help you addressing to the issues that you may have. And honestly, in life, there are, I will always say, two major challenges. One is death, one is divorce. The first one, you cannot avoid it. The second one, you hope you can avoid it, but a lot of times it's becoming a little bit difficult.
And it's not always your decision.
Just because you don't want to get divorced doesn't mean that you can avoid it. But this is exactly the reason why, if we want to navigate this risk properly, you should probably find an advisor who can help you with these kind of issues to look into things more in depth. And now I want to move a little bit more to the trustee. You just mentioned private trust company, but this is another topic that we can spend another hours and a half, maybe two, talking about it. Now, let's say that it is the normal professional trustees, those that are listening to our podcast today. When a trust is drafted into a divorce, what are the trustees' non-negotiable duties and liabilities? How do they walk through that tightrope of neutrality between warring spouses and still protect the trust?
Well, the overriding point for a trustee is, of course, that they are there to serve and protect the interests of their beneficiaries of the trust. And what that will mean in any given situation will, of course, vary. But very often, the situation we're confronted with in the divorce context is that a trust has been set up and either by one of the parties to the marriage or by somebody else and their beneficiaries. And the divorcing spouse is trying to say, well, look, these assets in the trust should be available for distribution on the divorce. I want my lump sum, because I can see all of these assets sitting there and they're very valuable. That provides a whole host of challenges for a trustee, particularly where it's an offshore trustee. And the reason for that is that they're not within the jurisdiction of the court, generally. And the question for them is, do they participate in the divorce proceedings as one or other of the parties might want them to? Very often what you'll have is the party that wants access to the assets will try and bring the trustee in. The party who doesn't want the assets being brought into play will be trying to keep the trustee out of the proceedings. And so there's always that battle. And the trustee has the difficult decision to make about what it should do and the extent to which it should get involved. Because I think the conventional wisdom has always been, if you are a trustee in a different jurisdiction, a different place, you're the offshore trustee, and there's a battle going on in a jurisdiction like England or Hong Kong, you stay out of it. You don't let the court make orders that will let it grab your assets. And that certainly has been, as I say, the conventional wisdom. But I do think that the world has moved on slightly because judges have become much more proactive and, dare I say it, imaginative in the ways that they have looked to get their hands on assets and be able to distribute them. And so the trustee's got a very, very important and difficult decision to make about what it does. And the main area I always think of that, or certainly the first point at which that arises, is when they're asked for information about trusts. Because very often you'll have one party saying, well, don't give them any information. We don't want them knowing what's in the trust because that'll only just encourage them to go after them. But very often, in my view, giving some information through one of the parties to the divorce and showing the court that this is a legitimate structure which does actually afford the protection that you want it to afford can be a much better solution.
It's a very long way to say, if you're hit with a divorce paper, call a lawyer.
I didn't want to be quite so upfront about it, but yes, absolutely, because it really is. I mean, it's a minefield. I mean, there are so many things that can go wrong for a trustee because you find yourself, likely to be criticised by someone or other, depending on the decisions you make.
I always say that the only way that you can protect yourself properly is to get a court order.
And very often that will be the solution because, of course, for a trustee, the courts are certainly in their jurisdiction, in the offshore jurisdictions where you're dealing with an offshore trust, the courts are very receptive to trustees seeking guidance and saying, well, look, this is the difficult situation. This is what I think I should do. Will you confirm that it's the right thing? And that, in turn, that protection of a court order from their home court can be helpful in the divorce proceedings because the trustee may be told by the court, don't provide information. And then when the judge in the divorce is saying, well, look, why isn't this trustee doing it? You've got a bit of paper saying, well, look, actually, they've been told by their own court not to do it. So, yes, I completely agree with that going to court can be a really helpful solution.
But then, of course, it's not just, just go to court and then you are absolved from anything. Before you go to court, obviously, you need to look through your papers, documents, see what is it there? What is it that is helpful to you getting the court order, and your duty to make proper disclosure when you are making the application to court.
Yeah, and again, from a trustee's perspective, making sure that you keep good records throughout the administration is really important. And that's probably another topic that we could spend hours discussing, Alfred, is, what should a trustee have on its file? But what you're looking to show in this context, I always think, is that the trust is being run in accordance with its terms. And that, coming back to that question of control that we were talking about earlier, that people are not exercising control that they shouldn't be. So that you have this evidence that, the wealth creator might be saying, well, I think you should be doing A, B, and C, and the trustee saying, well, look, that's all very interesting, and we'll take into account what you're asking, but it's our decision, it's not yours, and we're going to behave in this way. I mean, in these sorts of contentious situations, one of the most powerful things for somebody challenging the trust is to have a whole list of requests from somebody, and every single one of them is complied with by return. An email comes in saying, I'd like a distribution of X. And they say, here you are, is the bank transfer's been done. And I think, again, it's about thinking ahead about how that will look and not just operating a trust as a bank account for one or more of the beneficiaries.
Operating as such is more often than we think it would be, right?
Absolutely, yeah. I mean, I think that is one of the problems. But again, we come back to this idea that it's quite hard to give up control, because if you have built a valuable business and you hand it over to a trustee, to then say to them, well, look, actually, I want a big distribution to buy my new yacht. To have somebody say, well, no, we're not going to let you. We don't think it's the right decision. It's quite a bitter pill to swallow.
It doesn't have to be like a distribution if you want to buy a yacht or a Ferrari, right? You can always ask the trust to lend you the money.
You can.
Or simply ask the trust to buy it for you for the benefit of not only yourself, but also other beneficiaries, so they can also enjoy the fun of having a yacht or a Ferrari.
Exactly. But again, we come back to the thing that if the trustee is going to do that for wider benefit, a court's going to look very sceptically at it if only one beneficiary ever gets to use it.
Okay. We touched on earlier about the judicial attitude towards the trust. We always say that the judge seems to be very cynical about the family trust and is always seeing it as a way to avoid marital assets being split or spousal claim. Do you see it as a trend and that the court is becoming more and more ingenious in finding a way to get around trust?
Yes. It really has, because I think there has been a period of time when judges have been confronted with situations where there are valuable assets in a trust and being told, look, there's a trust, you can't touch this. And they've rather viewed it as a challenge that they have decided they're going to rise to. So we've seen in the courts, as I say, this focus on control and saying, well, look, can I practically compel the trustee to comply, and they'll do that through a number of means. By, for example, making quite strict orders against the party who's a beneficiary, depriving them of the actual marital assets that are in their hands, on the basis that the judge will say, well, if I take all of the marital assets and give them to the other spouse, I'm pretty sure that something will come out of the trust to make up the shortfall. And that's been a fairly common tactic of judicial encouragement, it's called, to encourage the trustee to make up that shortfall. But actually the courts have gone further in a different context where creditors have been challenging structures, where there's been a power to revoke the trust. The courts have allowed that to be used by creditors to step in and do that and get the assets back. Similarly, courts have at their disposal the doctrine of Sham, which is basically where the piece of paper says one thing, but the reality is different. They say, well, actually, these assets aren't really held on the trusts that you say they are. The reality is that they belong to one of the parties to the marriage.
But it sounds exactly like those trust cases that we have come across in the past, which has been severely attacked, from Otto Poon to Zhang Lan, all these names that become very familiar not only within the trust industry, but also to those clients who's looking to set up trust or to use trust to ring fence to protect their wealth. They put it this way, not ring fence. So what I would say is that the mistake that they committed in the past is just use it like their own pocket and tell whoever, trustee, lawyers, whoever, do what they say. And this is the big no-no, isn't it?
It's as I say, it's very difficult, but it really is a balancing act between control and protection. I mean, if there is a single message that I can sort of impart in this podcast, it really is that the days of thinking that you can have it all by keeping control but getting protection of your assets, I think those days are gone because of the way in which the courts are rising to the challenge of getting their hands on assets that are held in trust. I mean, I wouldn't want listeners to think that trusts are not a good structure. I think they really are. I mean, as I say, from succession planning perspective and asset protection, but you've just got to get it right, and you've got to accept that the cost of the protection is ceding a degree of control, which makes it all the more important at the outset when you're doing the planning, Alfred, which you do a lot more of than I do, of working out what sort of structure and where the balance should be for a particular client. It's quite an involved and detailed process to get the right structure, and it means that, dare I say, the tendency in the past, going back 10, 20 years, of having off-the-shelf structures that are sold by intermediaries is probably not the best way forward. Again, promoting work for lawyers, but I think it really is important to have a bespoke structure that suits the needs of particular clients and their circumstances.
I think this is more than just the initial setup of the trust. Talking about the structure itself, that is important. The ongoing administration of the trust is equally important, because I can only imagine that an email between the client and the trustee, we shouldn't call them the client, but then the settler and the trustee, communicating over the disposal of certain trust assets, and the trustee complying with such requests is damaging enough.
Yeah, it really is. I mean, look, I wouldn't want listeners to think that what, as you said, we shouldn't call the client, but all too often is called the client, wants is irrelevant. It isn't. I mean, the law makes absolutely clear that the settlor's wishes are a material consideration for a trustee. So if you do set up a trust, you're well within your rights to write to the trustee and say, look, I think actually, my younger son, he's a bad and he's got a drug habit, or he's spendthrift. You shouldn't be giving money to him. The trustee really is under an obligation to listen to what the settlor says and to take it into account. And that's quite an important part of the relationship. But what they shouldn't be doing is just acting on request. And back to what we were saying before, treating the trust as a bank account. And I think that is one of the problems in administration, that it becomes very easy to lapse into settlor says jump, trustee says how high. And that is something that needs to be kept under review. Now, but of course, it may well be that uncontroversial requests is perfectly legitimate. And I wouldn't want listeners to think that that a trustee's job is to say no. It really isn't. But it is just to make sure that they don't store up problems for the future.
I think between a yes and a no, there are plenty of rooms for trustee to maneuver. And how to maneuver it depends on what sort of advice that they would be receiving, especially from the lawyers, on how to communicate properly in the course of their trust administration in order to make sure that this is watertight.
Yeah.
Yeah. And which brings back to the ultimate message of this podcast. If you don't know what to do, find a lawyer.
On that point, I mean, you're absolutely right. And, there are many variations between yes and no. And if I'm in a case where we're looking to attack a structure and say, well, look, these assets are supposedly held on a trust, but just look, one of the first things, if you've got the disclosure of those communications, one of the things that will make someone like me really happy is to see a whole series of emails saying, I want X to happen, and it happening by return, and it being very much a clear pattern of just doing exactly what's said. And I think trustees really need to think very carefully about the optics of it. I remember somebody once saying to me, in the context of lawyers, saying that what you should be taught at law school on the first day is never write a letter that you don't want read out in court. And I think that's sort of good advice for a trustee as well. Never have a file note or an email correspondence that you don't want to see the light of day in front of a judge, because when it becomes contentious, if disclosure of information is given, you are going to have to justify your position and say, well, look, it's all very well for you to say you're exercising an independent discretion. You're the one making the decisions here. But just look, there's 100 decisions here. You've gone along with everything without any question, without any scrutiny, and without any documentary evidence on your file to show that you've really applied your mind to it rather than just doing what you're told.
In other words, be prepared what your files look like and whether the court is going to look at it favorably. Don't do anything that you will regret in future.
Yeah, I think that's right. But of course, it's got to reflect the reality. I mean, what I'm saying is, the trustee has to be trusted to make its own decisions. And I think clients, when setting up trusts, just need to be prepared and for the reality of that actually, if they want a robust structure that is going to protect assets, they will need to be prepared for a trustee to do things that they don't necessarily want. Now, that might not be the right answer for them, and it might be that they want to build a structure with a greater degree of control over various things. They might want to have a veto on things, and that's great. That can all be accommodated, but the trade-off is that it might not provide as much protection against claims in a divorce or another in other contexts as it would if they cede control completely.
It sounds to me that this is like the soundbite that we are going to give to our client. Just because you don't want something to happen, it might be good for you at the end.
There is a difference between what you want and what is good for you.
If only you always know what you want, then I don't have a value to you.
But it is difficult. I mean, I can completely sympathise with a lot of the people that we're talking about are really dynamic go-getters who've been great successes in the business world, who are used to making decisions and getting results and having people, trust their judgment. And so that exercise of giving up control can be really tricky and counterintuitive.
And if you want to not give up control, but coming across as giving up control, it sounds totally contradictory, but there are things that can be done. What I can say is, call us. Really have a discussion with us on how to structure your trust in a way that will be robust in future.
Yeah. I mean, but that scrutiny will involve looking at, whether the reality reflects what's on the piece of paper. And so, as I've already mentioned, this idea of a sham that if you have got a situation where the trust says, well, this person doesn't have any control over anything, but actually the evidence is that really they do, the court will say, well, the trust doesn't really operate in that way and can go as far as to say it's a sham. So what you have to be prepared for in all of these situations is to justify the reality of the situation. A piece of paper which says one thing really won't protect you if things aren't run in that way. And that's a very important piece of, it's a very important thing for both clients and trustees to bear in mind when entering into these structures, and critically as the structure continues during its lifetime.
To wrap up, I have only one question left. That is, what's the most surprising and unexpected outcome you've witnessed in a trust-related divorce case? And what lesson did it teach you?
Well, it was probably in a case I was involved in here in Hong Kong, where we had a divorce going on here, valuable family trusts that had been set up for succession purposes. They weren't asset protection trusts, but one party to the marriage was trying to bring them in. The trustee did what you'd expect a trustee to do, and what we've just been saying that they ought to do. They went to court, I think, and were told by the court in an offshore jurisdiction that they should not be getting involved. But there were other family members who were beneficiaries who wanted to get involved in the divorce proceedings because they wanted to stand up in front of the court and say, well, look, actually, this trust isn't just about the husband. we are all beneficiaries, and this trust, our interest should be taken into account. And they applied to be allowed to participate in those proceedings. The court said no, which we thought was quite surprising. But I think the lesson there is, again, that this scepticism sometimes from judges can manifest itself in a number of different ways. And I think in that case, the judge was really saying, well, look, if the trustee's not going to be prepared to come here to court and be subject to my orders and be required to do what I tell it to do, I'm not going to have somebody else come here and get the benefit of making a case without the jeopardy of if it goes wrong for them, my orders being able to be translated into real action.
But it sounds to me that just because the trustee is not submitting to the jurisdiction of the divorce court in Hong Kong doesn't mean that the judge is not going to make any order against the trustee.
No, I mean they often will. They'll try, and then there are all sorts of complications about enforcing in the trustee's own jurisdiction, because if many of the offshore jurisdictions have what's called firewall legislation, which prevents specifically foreign divorce court orders being enforced in those jurisdictions. Now, another layer of complexity is, of course, that the assets that you're actually fighting about will very rarely be in those offshore jurisdictions. If you've got a Hong Kong divorce, very often the property we're talking about being divided might be valuable real estate here in Hong Kong, and that means that the court might well say, well, look, actually the assets are here, and I will make an order. And so it can be quite difficult in that way, because the courts will seek to do what they can to come up with a just outcome as they see it. And I think that, as a takeaway point, it is quite important nowadays, particularly, to be seen to be the good guys in a dispute, by which I mean that in the past there was a tendency perhaps to say, well, look, I don't really care if I'm viewed positively or negatively by the court. These assets are protected in a structure. You can't touch them, judge. Do your worst. Well, actually, the courts have done their worst, and they've managed to find ways around structures in a number of cases. And therefore, it's much more important, I think, to be able to project a meritorious position. And that goes on a number of levels, particularly about the purpose of the trust, and saying, well, look, actually, this isn't about asset protection. It's about legacy and succession planning, and to have a trustee that isn't being seen to be just sort of pulling down the shutters because it suits one of the parties to the marriage to do so. And I think that overall impression that is given from the trust's perspective, whether it's by one of the parties to the marriage or the trustee, is really, really important now that the courts are becoming much more activist, interventionist, and proactive in attacking structures.
Let's see if I'm correct in that respect. If the trust is not going to be intervening or involved in the divorce proceedings, it's almost certain that there will be a first influence. So, might as well for the trustee to come forward and explain to the court that the structure is actually legit, that it should be protected instead of just attacking it for anyone's benefit.
Yeah, that's completely right. Now, there's, I've mentioned balancing acts a few times, and again, this is a balancing act for the trustee. It's a very, very complicated question to answer of how far the trustee should go, because one of the things that you don't want to do is unwittingly submit to the jurisdiction and make yourself amenable to orders being made. But thought should be given to the things that fall short of that. So, for example, giving information perhaps through a party and saying, well, look, you're a party to this litigation. You can give this information. We'll write to you with it, but you should put it before the court to explain the trustee's position. And that might be a solution, because I say that the impression that is given by the trustee should be, as much as possible, a positive and cooperative one, but not one which unnecessarily brings the assets within the grasp of the court.
It is a difficult job. It's particularly difficult when the trustee often have no previous experience in a divorce setting. Hopefully, they have not gone through the divorce themselves on a personal level, but also facing similar situation when they are hit with a divorce petition or court document. And it is so complicated to do the right thing that the only way that they can discharge their duties is to go to a lawyer and seek proper advice.
I was about to say, it sounds like another situation where they need to give you a call, Alfred.
Thank you very much, Richard. We have learned a lot throughout this podcast. And if there's anything else that we got on this topic, either from ourselves or from our audience, we know how to find you.
Thank you, Alfred. It's been a pleasure.
Thank you very much.
We invite you to continue exploring the Hip Talks podcast series, rich conversations that unpack Hong Kong's most pressing legal matters. You'll discover our full catalogue of episodes waiting to engage you through multiple channels. Visit our website at www.hugelandip.com, where past discussions live alongside other thought leadership in our Insights section. For listeners who prefer streaming on the go, we're available across all major podcast platforms, including Apple Podcasts, Spotify, Google Podcast, YouTube, and Stitcher. What makes these conversations truly meaningful is hearing from engaged listeners like you. We welcome your perspectives and topic suggestions at hello@hugelandip.com. Your input helps shape future dialogues. If you found value in these exchanges, consider sharing them with others in your network who appreciate nuanced legal commentary.